All right, welcome back to the House Judiciary Committee this Thursday afternoon, January 15th. And we're going to turn our attention to H5 for some additional testimony. And we're going to start on Zoom with Sheriff Jennifer Harlow. Thank you for being here. And if you could unmute yourself and identify yourself for the record and proceed.
Thank you, Mr. Chair. My name is Jennifer Harlow. I'm the Sheriff of Orleans County, and I'm also the
Thank you.
president of the Vermont Sheriff's Association. So thank you for allowing me to come and speak with all of you today. I really appreciate it. Sorry I'm not there in person. But this bill is very important. The Vermont Sheriff's Association supports this bill, as we've heard through the state's attorneys and sheriffs training McManus. It's one of their top 10 priorities this year. So thank you for listening to them. A little background, I've been in law enforcement for going on 30 years now, and for over 10 years, probably a little bit longer here and there, still doing the cases. I investigated, I was assigned to a special investigations unit and investigated sex crimes against our children. Was part of the Internet Crimes Against Children. So I've been doing this for a long time, and it's a huge passion of mine. In regards to the bill that you guys have going forward, it's, again, very supportive of it. I think raising the age would be very beneficial. As you all have heard, and I'm sure you all are aware, these crimes are very egregious, and it takes a tremendous amount of courage to reach out for our young people to come forward and disclose what has happened to them. And when they first disclose, you know, they usually hope, or they're doing it to someone they trust. So, and often they have to disclose on several different occasions. So being able to have those individuals come and testify and explain to them what that person has disclosed to them is huge. That support is really tremendous. So go ahead, sorry, Chair.
No, go ahead. Go ahead.
So that was, I mean, I just really wanted to impress on you that this bill I feel is really important, which I feel like the room really also represents that as well. Especially when we're getting to our teenage years, young people, it has changed a lot over the years. So there's so much for them to worry about, and they're concerned about their peers, and just having extra support and throughout that proceeding is, I can't tell you how important it is to them. So again, it's not taking away the right for anyone for them not to testify or anything. It's just giving them that extra support, which is great when you're during these tough times for them.
Great. So any questions for Sheriff Harlow? I'm not seeing any questions right now. No, I really appreciate your perspective from law enforcement and perspective in your past work with this. So I really do appreciate that. And thank you for being available this afternoon.
Thank you very much. I hope you all have a great weekend.
All right. Thank you. All right, and we'll go to Kate Lamson from the Defender General's office, who's also on Zoom. If you could identify yourself for the record and proceed. Thank you for being here.
Good afternoon, Mr. Chair. My name is Kate Lamson. I am a public defender in Bennington County. Thank you for letting me testify remotely as well from the Banana Belt down here. Quite a drive. I've been a public defender for over a decade now, and before that, I worked at the Bennington County State's Attorney's Office for a few years. And I respectfully oppose the bill for several reasons. The first of which is that I don't think as drafted that it meaningfully protects the age group that it is looking to protect. The second is because I believe that the bill is inconsistent with other age requirements within Vermont's laws. An example of that is the requirement that in sexual assault cases of somebody under the age of 16, that person is not allowed to be deposed in a criminal proceeding. And also, of course, the fact that somebody could potentially be charged either in delinquency or adult court for a sexual assault in that same age range. And the third reason is because I think that it does chip away at one of our law's foundational requirements, which is the right to confront your accuser. And so I'm just going to talk just briefly about those 3 points. I certainly appreciate Sheriff Harlow's comments. And that's actually, it's very interesting because I never thought about it from the perspective of support, meaning that the child witness that would be testifying would feel more supported in the court case because there was people testifying about what they had said at different occasions. So that's interesting for me and certainly something to think about. But the problem I think with that is that, as you know, because within the bill, we've got the section that says that they have to be available to testify in court under Rule 807. And how the courts have interpreted being available under 807 in Vermont is that the child has to be physically present at court to testify under oath under cross-examination. So what we typically see happen is that these statements would be introduced by, like Sheriff Harlow said, trusted friends, family members, perhaps, counselors or therapists that the child had disclosed to. Those folks would testify to what the child had said. And then the child themselves, most of the time, is still required to take the stand and be cross-examined. And of course, that cross-examination is going to include all of the surrounding circumstances for those first disclosures, because it's a consistent statement. So the defense attorney is going to want to, try to poke holes in that as much as possible. What that results in is a longer cross-examination for that child than what would normally be part of a good defense. So the only way under 807, right? So the child has to be available, and there's those certain exceptions within that rule. And the exceptions would make it so that the child could testify via closed circuit, right? Television or via recorded testimony. But we have very recent Vermont case law where our Vermont Supreme Court has interpreted that. And they have actually set a pretty high standard for any child to be able to testify that way. And that standard is that the child witness would have to be traumatized, not by the courtroom in general, right? Not just sort of the same way that anybody that gets up in front of a group of people and talks could be traumatized, but by the presence of the defendant specifically. That showing has to be made. And then it also has to be shown that the witness would suffer more than mere nervousness or excitement or reluctance to testify. And then it also has to be shown that all of this would impair the child's ability to communicate. So, what we saw in State v. Sylvester, which is where I'm getting this language from, is that the Vermont Supreme Court overturned a conviction and sent the case back for a new trial, finding that there was not enough evidence to support that. So I just don't think that that this meaningfully protects that age group, because unless you can make that showing, which is obviously going to be more difficult for 12 to 16-year-olds than it would be for children that were younger than that, then they're going to end up testifying anyway and potentially testifying for longer. The other reason is that the bill.
Before you move on, I have a question on that point first. Go ahead, Karen.
Yes, thank you for being here. I apologize. I feel like I'm not following that, and I want to understand that piece of it, because obviously protecting the child is important. So if you can maybe summarize it again of how you feel, because what I think you're saying is this proposed law might be doing opposite of what we're hoping for. Is that?
No, that's right. Because again, I think that it does make cross-examination longer. And the reason for that is this. My belief, based on my experience and talking with colleagues and the like, is that most of the time when these hearsay statements come in, so assuming if the law wasn't changed, most of the time when hearsay statements come in for children that are 12 and under come in to evidence, right? Like Sheriff Harlow said, they come in through trusted friends and family members or other people that get up on the stand and say, after school one day, little Tommy, confided in me that this has been going on at home. But within the law right now, and the law as it's proposed, is a provision that says, okay, even if we're going to let those hearsay statements into evidence, that child still has to be available to testify in court. And the way that the Vermont Supreme Court and a lot of federal courts have interpreted that word, right, being available, is that they actually have to be physically present at court, and they have to be available for cross-examination under oath by, me or whoever the other defense attorney is. When a child's statements have come in, let's say through a counselor, instead of just asking the child about the instances of abuse that they're claiming happened, I also have to ask them, how do you know this counselor? Potentially get into the areas of why do you trust them? All of those other things have to be delved into, because obviously it's good for the state, right? It's good for the state to be able to show this child isn't just telling you this now. This child also told these other folks, and that makes it more reliable.
Okay,
Does
so
that
that's how, so, yes, and if I can just clarify that I'm understanding it, that this opens up that there's more that could be discussed or examined in testimony with the child. And I think on the other side, though, it is allowing the hearsay pieces. So it seems like it would be a case by case, like where would all the parties want to see it. So I hear your perspective of it, and I now can put it in the bigger picture. So thank you.
Yes. And just moving on to my second point, that we charge kids, 15 or 16-year-olds, sometimes even in adult court, with sexual assault. And we also have a rule in Vermont Rules of Criminal Procedure that says that defense attorneys are not allowed to depose people that are under the age of 16 who are witnesses in cases like these, the same, class of cases, sexual assaults and the like. And recently, I think the legislature also, either last year or the year before, expanded that to include children who were the subject of cruelty to a child charges with serious bodily injury. So to me, that seems inconsistent, that we would, at the same time say this class of kids from 12 to 16 is so vulnerable that it is okay for us to introduce their unsworn testimony in a criminal case. But we also have to protect that testimony should come in, but also we're not allowed to depose them, which of course makes it more difficult to know what they're going to say. So it's a shifting. Again, there's no doubt about it that the bill as proposed, I think, would make it easier for the state to prove these cases. But it does so, again, without meaningfully protecting that class of kids, because they're still going to be subject to having to be available in court. And a little bit more on that point is that I also think, and perhaps I am misstating, excuse me, I've got those automatic lights, that these cases they're not particularly easy for the state to try, and sometimes for the state to win. It is, in my experience and what I have seen, prosecutors generally want to call these witnesses anyway. These hearsay statements come in via this rule, which is sort of prejudicial to the defense, but then the child testifies anyway. So they're not protected, but the state still gets this big advantage. And that brings me to my third point, which is the balancing that the law has to make between the confrontation clause and certainly legitimate state interests in protecting vulnerable people, and certainly children who are involved in cases with this classification of charges are vulnerable. But to balance that, to make it worth chipping away at one of our foundational constitutional rights, the result of that should be real, concrete, enhanced protections for this class after showing that this class needs that type of protection, rather than passing this as it stands. So that's all I have, unless anybody has questions, which I'm happy to answer.
I'm looking around the room. Ian?
Just one, did you give us a site for that case?
For State v. Sylvester? Sure.
Oh, great. Yeah.
It is 2025 Westlaw 3684437. And it's a 2025 case. It's a very recent decision.
Yeah. Okay, great. Thank you.
So I'm not sure I thought you said it chips away at a fundamental right of confrontation. I don't know if I really caught that in your further explanation.
So, you know, the idea behind the confrontation clause is that anytime somebody is going to accuse you of something, they should have to do it to your face. That's the reason why defense attorneys love it so much. This idea that, because it's sort of rooted in common sense that we all know, right? It's a lot harder to lie to somebody's face than it is, or excuse me, it's a lot harder to lie to somebody's face than it is, you know, behind closed doors, or certainly, as we know from current events, behind a computer or a keyboard. So the confrontation clause is it is part of our Vermont Constitution under Chapter 1, Article 10, and it says that we have the right to confront any accuser against us. So when we allow these hearsay statements in through other people that are not the accuser, right, which in this case would be the child witness, we're allowing those statements in without any confrontation because the child witness isn't there to confront, and, you know, in the same instance. And that's a big deal, because it is such a fundamental right. And again, I think that if we're going to chip away at that by allowing an even larger classification of children to have those hearsay statements be admitted, then there should be some showing that, you know, that it's necessary, or that it is going to result in real meaningful protections for that class, rather than those hearsay statements coming in and then the child having to testify anyway. Does that make sense?
Only kind of, except that you have the right under this law to confront the witness. So I mean, and it sounds like you have the opportunity to confront the witness, not just about the statements of whatever happened, but the relationship with whoever is offering the hearsay. So that's why I wasn't.
I hear you. I hear you. I guess it's a nuance. You know, the confrontation clause protects against any hearsay statements, right? So that's why the hearsay laws exist, is because you're not, you know, we can't have people just be tried on something that somebody said to somebody else, right? So presumably, right, like I said, in most of these cases, a judge would say this child witness has to be made available. But there is a provision under 807 that allows for the child to either testify via closed circuit television or via recorded statement, where the defendant may or may not be present via order of the court. So it is possible under the proposed rule change that those hearsay statements would come in through counselor, trusted family friend, whomever, and then the defendant would not be able to sit in front of the witness who actually said those things and be confronted by them.
Except that I thought that rule 807 applies to 12 and under, and so it's already current law that hearsay can come in. So for the 13, 14, 15-year-olds, there would be that right of confrontation in court. I believe.
You know, you're right. No, you're right. It is 12 and under 807.
Yeah. So there's the confrontation. I understand your other 2 points. I just wasn't quite getting confrontation point. So just a question, if you had, this is asking you and how you practice on this, and then I have a couple other people want to ask questions, but if you had somebody who was providing like 4 or 5 people that this person gave a statement, you know, the out of court statement, would you argue that that's cumulative evidence? I mean, maybe this is not a hypothetical that you.
No, I certainly would.
Yeah. I mean, okay. because that was one of the concerns that it was raised in some earlier testimony that, well, you have this out of court statements to several people, but it seems to me that that pretty quickly could become cumulative and not something that would be allowed, but that, whatever. So I have Tom and then Karen, have questions, and then Ian.
Thank you, Chair. I was just gonna ask simply your point of view on video evidence, what your opinion would be, live or recorded.
I don't think, yeah, I don't think it's as effective. And I think that prosecutors know that. And so, you know, they're not likely to make those proposals unless they think that it's necessary. I've only seen it done a couple of times. And the couple of times that I saw it done, the child witness was actually at court. And then the closed circuit system was set up in a conference room outside of the court. So, I don't, not being a child psychologist, I don't know, you know, how much that protects the kids, if that really is a help or not, I don't know.
From your point of view, a live hearing is really the only way to have any kind of hearing, or do you participate in video hearings now?
I do participate in video hearings now. Not when, if I have any opportunity to be side by side with my client in court, that's how it goes. But yes, sometimes, for example, with regional arraignments right now, I represent people at arraignment over the computer where I'll be standing in court and they'll be at one of the jails. And I don't think that is as effective.
Thank you.
I think Karen's skipping. So.
Great. Yeah, I just had one question. So one of the things that we've talked about, oh, and also thank you very much for being here to testify. It's really helpful to hear from practitioners. Some of the things that we were talking about is kind of the safeguards that are in 804A anyway, that we're not really talking, we're not touching really, that, you know, you have to satisfy these different prongs to actually be able to get this hearsay evidence in for under 12-year-olds currently. I'm kind of curious from your perspective, in the cases that you've done where the state has tried to move in hearsay evidence like this, how rigorous the process is in going through those 4 different factors and determining whether that hearsay is actually going to be admissible or not.
But pretty rigorous.
Okay.
And I say that from my experience of, you know, I don't have an experience with a very young child. So that, you know, that may be different, but I think that judges are as careful as they can be, because they know that there are constitutional issues at play when making the determination. So I don't think that it is lopsided in that way. I think that the courts do a good job of trying to balance the interests.
Yeah. Okay. Thank you.
Any other questions for Kate? I don't see. Thank you very much for being available. I really appreciate your testimony.
Thank you. Is it okay if I stay on and watch the rest?
Absolutely. Absolutely. Okay. We may have further questions for you that come up. You never know. That's fine. I appreciate it. So we're going to find my list here and go with Samantha Prince. If you could identify yourself for the record after you unmute yourself and proceed with your testimony. Thank you for also for being here.
Yeah, thanks so much for having me. I appreciate it. So my name is Samantha Prince, and I am the Director of Outreach and Advocacy for the Vermont Children's Alliance, which is the state chapter that supports all of Vermont's child advocacy centers. Just in case anyone doesn't have the familiarity with child advocacy centers, the purpose of all of our child advocacy centers, which I'm going to refer to as CACs, if that's okay, is to offer a safe, neutral space for children and adults to come and have a forensic interview done regarding whatever the allegation of their abuse is. And by doing so, they are in a singular room. The CACs are all like neutral and set up, designed to be like a comfortable, trauma-informed sort of spot. So it's not the DCF office, it's not the police barracks, it's supportive in and of itself as an entity. While the child is interviewed, law enforcement and or DCF are able to observe that interview. But the interview itself is taken from the perspective of learning everything the child has to offer that they're able to recall and able to share regarding their allegation of abuse. During that forensic interview, the child is asked to describe their understanding of truth and lie, and they're able to agree or promise to tell the truth during their interview. Sometimes after the interview, an officer or detective rather may ask them to swear that everything they've talked about has been the truth, depending on their age and understanding, and obviously their parents' presence for that. So the Vermont Children's Alliance has submitted a letter for your review, much like many of our stakeholders, offering our support of this bill, because this bill will bring Vermont by passing this, Vermont will be able to be current with regard to the research that already exists, that this is the developmentally appropriate thing to do for children. Several other states, you probably hopefully know this already, have passed a 16 as the hearsay exception law. So the majority of American states have some sort of exception, hearsay exception for children, and several of those also have it as 16 and under. So Vermont would become current with other states by passing this as well. In addition to that, the forensic interview is designed to be trauma informed. And by doing that, it offers children an avenue where they can present information in a protected manner. So there isn't an opportunity for the child to say something that is not of their own words, because it is a slow and gentle process, the forensic interview. So they're able to really reflect and recall whatever they're able to remember in a way that is conducive to their thinking and speaking patterns. So some kids, for example, don't recall memories in a linear pattern, which is totally okay. The forensic interview can adapt to that. Whereas in court, those things can be challenged. The ability to recall information and how children present information can be challenged. And children are very, very susceptible, very, very vulnerable to those types of intrusions and questions, because their brains are trying to recall in the best of their ability, but in the courtroom, the questions aren't tailored to help them do that. So it can be very, very challenging in that setting. So having protections for them to be able to present their testimony if needed with protection, whether that's closed circuit or by another means, and offering these pieces of evidence to be able to be submitted as hearsay is fundamental to what is in the child's best interest.
Questions for Samantha? I don't see anything. I think it was pretty straightforward. I appreciate your testimony.
Yeah, thanks so much for your time.
Thank you. All right, we'll go to Kelly Woodward, who's on Zoom as well. Nice to see you again, Kelly.
Thank you.
Appreciate you being here.
Thank you. And thank you for inviting me to testify and allowing me to do it virtually. I appreciate that, being stuck way up here in Franklin County. By way of introduction, I'm Kelly Woodward. I retired in July from the Franklin County State's Attorney's Office, where I was the victim advocate for 30 years. I'm currently in a position as the victim advocate at the Northwest Unit for Special Investigations. I know you guys have heard a lot of testimony, and I appreciate everyone who's testified ahead of me, and I will keep my remarks brief and hopefully pointed in the direction of how this will benefit actual victims who are child victims of sexual assault. You've heard, and you're going to hear again, these cases are really hard. They're really hard to bring to prosecution. They're really hard to prevail at a prosecution. And they come with their own set of problems, right? We get delayed reporting, we get no physical evidence, we get that the only witness is the child who is present during the abuse. So there's a lot of difficulties with these, especially with this age group of teens. I get a lot of these kids who say, I can't go forward. I won't go forward. You can't make me. Why do they say that? A variety of reasons. Fear, anxiety, trauma, embarrassment, shame. What I hear over and over from these older teens is, why do I have to do it myself? Who else is on my side? Who else is going to go in the courtroom with me? And I think this bill, particularly to these teens, offers that bit of cooperation that the state's attorney can offer that helps them not be so alone. If you take a scenario where an abuse occurs, a teen tells their friend, maybe they tell their grandma, they don't want it to go any further, they tell them don't tell anybody, and then years go by or a period of time goes by, and now they're disclosing again, maybe to someone who's a mandated reporter, or they're just tired of carrying the weight and they disclose. Those previous statements can come in and that can corroborate what they're testifying to today. So I think that really empowers victims. It helps deal with that fear and the isolation and the feeling of, why am I carrying the whole weight of the case on me? Why can't somebody help? And I think that's what this bill does. And having just listened to Ms. Lampson, I agree that it's probably not protecting child victims from having to testify or having to be cross-examined, but it gives them some additional support so they feel more comfortable, they feel corroborated, and it helps the jury too. If you just listen to a child say, this happened to me, and 3 years ago I told my grandma, okay, but now you also get to hear grandma say, she told me that 3 years ago. It adds that credibility and adds some cooperation for that teen victim. And I think too, a lot of defenses in trial are based on teen conflict, right? She only told because she had a fight with that kid, or she only told about her stepdad because he set a new rule and she didn't like it. If you have a disclosure made in the past, it kind of evens out that. It's not so effective as a defense strategy if a child's already said previously that this happened. And yes, the fight or the disagreement they've had at the time of a disclosure to authorities might be because they've had a fight. Did I say that right? Anyway. But we know the truthfulness of their statement is going to be shown because they previously disclosed it. So I think that helps, and it helps teens. The other thing I hear a lot, and I hear it a lot in the public, and I hear it everywhere, is our teens are so much more mature now. They're so grown up. Well, I take a real offense to that. I think our teens are more vulnerable now than they've ever been. These are the kids that lived through COVID, right? These are the kids that lived through COVID. They were isolated. They didn't have peer-to-peer interaction. They were lonely. And they missed out on that whole section of development that you get when you engage with people face to face. Those are the teens that we're talking about. These are also the teens who rely on social media for everything. And they are bombarded day after day, all day long, with mixed messages around sex and sexuality, what you're supposed to look like, what you're supposed to sound like, what you're supposed to do, how you're supposed to dress. It takes away the individuality of children. And it's very confusing. And it all leads to making them more vulnerable and more likely to be abused, and also more likely to not be able to testify in court. And I say this because I see it more and more often. Our forensic interviewers are great. And you heard Sam Prince talk about, the goal of a forensic interview is to get the information and not to judge what you're getting. But now we're asking our forensic interviewers to interview kids whose most comfortable language is not speaking face to face. Their most comfortable language is texting. And that creates a new challenge for us. And the forensic interviews that are done with older teens are the same exact forensic interviewers that we do with our younger teens or even our younger children. Again, you heard Sam Prince talk about the goal of that forensic interview is to get to the truth. So you have that same truthfulness or the same goal of truthfulness, no matter the age of the child. So you have it with your older teens as well as the younger teens. And again, there's a lot of protections still in this bill for defendants. And again, I want to say that I don't think that this bill, the goal of this bill, the only goal of this bill is to prevent children from having to testify. What I see it doing is providing additional support and cooperation when they do testify. Anyway, I ask you to please support teen victims and pass this bill. Thank you.
Thank you. Questions for Kelly? Yeah, Tom, thanks.
I couldn't let you get away without a question. The one thing I've been speculating about since we started taking testimony on this is the small slice of time there is between 12 and 16 years old and the variability of maturity that can be in there. Like you can have a 13-year-old be very mature, maybe beyond the 17-year-old, or, you know, I'm 58 and I'm 16. Can you speculate on that a little bit? Do you have any information?
I mean, I have anecdotal information only in that. I think maturity, I mean, I can have a 9-year-old come in here who acts more mature and seems to be more able to handle stress than some 16-year-olds. You know, it's such a small slice of age difference. I don't think we can say that a 16-year-old is automatically more mature or more able to handle stress than a 12-year-old.
Thank you.
The questions? So I have a question. I'm not sure it's for you but your testimony kind of brought this up, but I think I'll ask you and maybe other people want to weigh in on. So I'm feeling there's two reasons to have this, and they're maybe interrelated, and I think you kind of talked about them as interrelated, and that's the corroboration of the testimony of the child and the protecting of the child. And it seems like the corroboration, like just separately, I could understand a prosecutor or somebody who wants to convict individuals who are alleged to have committed these crimes, that is a benefit on the scale for them, the corroboration. But that's kind of unfair to the defendant having that hearsay for corroboration. So how much is that really also benefiting the child? And I think you had a testimony more than anybody else that really kind of tied those two things together. But could you expand on that a little bit further? Because that's really the bottom line in my view that we're weighing is obviously the fairness to the defendant and also trying to get the case right, but also protect the child as much as we can or help the child.
So first of all, I think that any witness that's brought in is subject to cross-examination by a defense attorney. So I think that takes away any benefit that the state may have over a defendant. They have equal access to that witness. The way that I see it benefiting or helping a child is the child's not alone anymore. And I can't tell you the number of times I've heard kids say, yeah, but who's on my side? Who's gonna help me? And that when kids go into a trial and there's not 804A exception, they're sometimes the only fact witness we have to testify. That's it. That's the state's testimony. That is so isolating for kids. That is so scary. It's put so much pressure on them that some kids just can't do it. They just can't go it alone. But if we say, you know what, you told your grandma about this 3 years ago, and she's going to be able to come in and talk about what you said, even if it doesn't help the case, it helps that child. They're not so isolated. They're not so afraid. There's somebody on their side. Do you know how powerful that is? That somebody's sticking up for you? that's the benefit that I see for victims in this bill.
I see. Thank you for that. Samantha, did you want to weigh in on that? I saw you show up for a moment, and that was the signal that maybe you wanted to weigh in on that question.
I did. I couldn't figure out how to raise my Zoom hand, so I apologize. Thank you so much.
No, that worked.
I just wanted to echo what Kelly is saying. That's something I explained that I work for the Vermont Children's Alliance and I speak on behalf of all the child advocacy centers when I speak with you today. But in addition to that job, I also am a forensic interviewer and an executive director of one of the child advocacy centers here in Vermont. And I wanted to just echo what Kelly is saying because it fundamentally is so important. And that's that it is so hard to testify in court. I know Ms. Lamson mentioned, beyond a bit of nervousness, but the vulnerability of these children and the pressure and the stress that they feel is sometimes insurmountable for them. I oftentimes have kids that will tell us that they don't want to go forward if they have to testify in court because it will be too overwhelming and too traumatizing for them. They feel like the judicial process isn't going to be fair to them. You have to recognize that these kids see stuff nationwide. And so they see other kids going through these experiences and they see them complaining like, this is how I got treated in court. Why would I even move forward? Like the court system isn't designed to be supportive of victims. And then here in Vermont, you see support for people that are committing crimes, and including the raise the age conversations that we've been having, where we're trying to protect potential offenders from their own brain development not being complete and what punishment looks like for them and how their treatment looks. And then when it comes to this bill, having the conversation about increasing the age to protect children during the court process to 16 seems like a no-brainer. And so I really just wanted to echo that because this week in Windham County, we have an adult victim who has been testifying about some very, very egregious sexual abuse that she endured for several years. And the way that the court process has been for her has moved the detective to tears. He has found himself sitting in court to support her because there isn't anybody else there. And that's a young adult that I'm talking about. And I just want the House to consider that, this committee to consider that the weight that we're asking these children to carry is unfair. It developmentally and psychologically is literally beyond their ability and what's good for them. And the research and science supports that. So I just wanted to echo that. That's very important.
No, I appreciate that. Thank you very much. Thank you.
Yes, thank you.
Anything else for Kelly? I don't see any. So thank you very much for being here, Kelly. And we'll go to Laura Byerly next. Nice to see you again, and thank you for traveling on down from Chittenden County to join us.
Thank you for having me. Good afternoon. By way of introduction, my name is Laura Byerly. I'm currently the director of the Victims' Rights Project in Vermont Legal Aid. I've been exclusively representing victims for the past 9 years, and it's been part of my practice for the past 19. And I wanted to come here to give you the perspective of the child witness's attorney. I represent children who are in these cases. I've gone through those 804A hearings with them. I have sat next to them during the entire trial, and I do my best to represent what they are looking for, what they want this process to be. And I hear them, and they are telling me, why is this all my job? They think that it's their job to prove this case. They think it's their responsibility and that they are carrying this burden. And this bill helps ease that burden just a tiny bit. It's not even a huge change, really. It's a small change, and it allows, as Kelly and Sam Prince have both said, it just lets the child know that they are not alone. They are not the only person coming in. They are not, somebody else is willing to say, I believe you. These are hard cases. These are hard cases from an adult who does these every day is starting to get a little cynical, frankly. But think about this from a child's perspective. In our courts, these cases take Ideally, a misdemeanor takes 6 months. A felony is supposed to take a year. Reality, felonies are taking 2 to 3. I have some that are on the 5 to 6 range. And we're talking about child victims. In an adult's life, a 2-year time period is a long time. It's really hard to be stuck in that trauma and to have to remember it by every little detail, or else everybody says you're lying. I mean, that's a really hard place for an adult to be. Imagine how that is when you are a child and you have to basically always say exactly the same things that you said to the police 2 years ago, 3 years ago. I mean, their entire world has changed in those 2 years. They have new teachers, they have new schools, sometimes they have new families due to this situation. And this just helps by saying, we're going to bring in the other people as well that you talk to, that are going to be able to say, you know, this is what they said at that time. Because the snapshot of what happened to this child is never going to be clearer than when we can talk about what was going on at that time and getting that information. I've had children come to me and say, you know, I told you what happened, but why is he still here? Why is he still in my neighborhood, that person who molested me? Why haven't you done anything about it? And it's not that we're not doing anything about it, but it takes some time, and it takes an awful lot of time in a child's life. And this just provides one small piece of support to say, you don't have to go alone. And I have worked with Kelly, and I have gotten some referrals from her as well, or I should say Ms. Wood, sorry, Kelly. But she, and we have been side by side with children going through this process. And over and over again, they want to know why they have to be alone. And I think this is a really good tool. But let's think about that process a little bit. Okay, so it's not going to be like, oh, we're going to bring in every school child from the 6th grade who heard this child say this thing on the playground. We're going to have a hearing ahead of time. We're going to have a motion filed. That motion is going to contain very specific statements. We're going to bring in the witnesses to those statements, and we're going to have them testify. We're going to have them testify under oath, and we're going to have them cross-examined by the defense. And we're going to pick apart why that statement has any indicia of reliability, or why really maybe we should ignore it. And we're going to do that for every single statement. And then we're going to choose which ones meet that threshold and can be admitted, and which ones cannot. And that's all going to happen ahead of time. And I mean, those hearings can last anywhere from just an hour, which is fairly normal, to multiple days. I've had a 804A hearing that has lasted more than 2 days. So there's going to be that opportunity to really pick apart these statements before it ever gets to the jury. Okay, before the confrontation clause is ever really implicated, we are going to be able to give the defense every possible angle to look at these statements and see why or why not they should not be admitted. And then the judge is going to hear about it. And the child is going to have to testify. I mean, we're not taking the child out of this situation. They're going to testify, and they're rarely going to be allowed to testify by closed circuit TV. So they're going to be there in front of the person who did the most horrific thing to them. And they're going to have to say what happened to them. But this gives them the chance to do that and not be the only witness that day in court. I mean, I've seen cases of sexual abuse with a child victim where the only witness is the investigating officer and the child, and that's it. Okay. And I think it's very hard for a jury to really understand what happened to that child if that's it. We need to know what was going on in that child's life. We need to know that little bit of the snapshot of what happened around that disclosure. And this gives us the opportunity to flesh that. And I think it's a very important move for us to take. And I thank the committee for considering this and bringing this forward. Children can be deposed, by the way. It's not that there's a blanket deposition block. They are allowed to be deposed. The defense has to file a motion. And those motions are considered, and the types of questions will be considered, and the protections that are needed will be considered. So there is no bar for the defense getting the information they need to make sure that they are addressing this case as it really is, and not just addressing it as, how can we intimidate this victim? So,
So I have a question as far as, so an individual, let's say a school counselor, it has heard a statement and they're testifying initially and maybe also on cross-examination. Is it just the statement, or would they be asking the counselor, well, how was this child when he or she came to you? What was her demeanor, and how was she feeling? Is that those kind of questions asked as well, not just the statement, but kind of get a sense of the situation that the disclosure happened?
in the 804A hearing, it was definitely asked.
The 804.
Yes.
Yeah.
And then it's up to the prosecutor and the defense about what they're going to do as part of the actual trial. Whether that information is going to be brought in, there might be motions filed about the extent of that testimony. I imagine there probably will be, along with all the other motions that we file in serious criminal cases. But that information definitely comes in under the 804A, so it is known and widely known to the defense that exactly what was going on with these disclosures. And they have the opportunity to make sure that these are reliable things. This isn't just something that was said because they were having a fight with a new restriction and they just wanted to make it. And they read an article and they wanted to make an accusation. I mean, we hear that kind of thing a lot, that's wrong. But so we get to examine that and find out, like, what is the thing that makes this a truthful accusation versus just somebody saying something because they were having a really bad day or feeling a certain way. So we get that information, and then it's up to the defense and this prosecution to decide what to do with it.
So I have some questions. And Kate, I'm going to go back to you after Laura is done, if you have any additional, but I'll let this testimony finish up first. But Karen, your question?
Yes, thank you for being here, and thanks for your work in supporting kids and teens through these really bad circumstances. My question is, so earlier we heard how this law could potentially be doing opposite of what we're looking for, because it could increase the testimony and the time that youth is on the stand. I'm wondering what your thoughts are about that.
I think they're already there, and I think the main instance of trauma is just getting there and having to sit there in that room. Extending it by an extra hour because we need to go into a little bit more about what happened when you said that. I don't see that as being as much of a detriment as them going there and then having no one else who's saying what they've said.
But not concerned.
I certainly would prepare and work with my clients, and I wish we had more victims' attorneys to aid in that process, but they definitely, I mean, I understand the concern.
Yeah.
And we certainly don't want to be putting a victim on the stand, especially a child victim, longer than they have to be. But we need the information, and the jury needs to hear it, and the defendant needs to have their opportunity to examine it. So, I mean, that is our process. And so it's a worthwhile trade-off in my view.
And it sounds like it would be something that you would consider just with all the other factors of, like, does this make sense?
Absolutely.
Okay, thank you.
Other questions? Yes, apparently not. So thank you very much, Laura. I really appreciate it.
Thank you for having me.
And we'll go back to Kate Lamson.
Just briefly, thank you. I just wanted to say that it's absolutely correct. It's not a blanket rule that we can't take depositions of kids under 16 in these situations, but it's very difficult. If the child advocacy centers, for example, do a great job of making sure that they take statements from kids that are very detailed. And unless the defense can show some compelling reason that they need the deposition because there isn't enough information, then we are routinely refused under that rule being able to depose the child because, as was said, we're presumed to have all of the information that we need to be able to go forward. But practically speaking, not being able to depose a child witness can also make things more difficult to resolve because we don't know the strength of the state's case. Aside from that, I guess I just wanted to say that I can't, imagine a better use of everybody's time than to try to protect vulnerable children. But what I'm hearing is that the main reason that this bill should be passed is because it makes it easier for the state to prove their case because the child feels more supported by having those other witnesses testify in that manner. And that does not seem to me to be a compelling enough reason, particularly when sexual assaults of a child carry a potential life maximum, and many of them carry a potential 10-year minimum. So I understand that it's not at all as strong of a case for the state if it's just the child and the lead officer investigating, but that's fair. Thank you.
I appreciate that. Thank you. Any other questions? I think that was all of the witnesses we have on this. We'll probably have some discussion tomorrow morning on this. I do have it scheduled for a possible vote. So we'll see if we're ready for that come tomorrow. Did you want to follow up? Did you want to say anything more? I'm happy to have you back on to give you the final word.
Sure, I'll take a minute. I don't have anything prepared, but why not?
You made the trap.
For the record, Jennifer Pullman, Director of the Vermont Center for Crime Victim Services. I did want to just remind us that what started this conversation back 2 years ago was that we had an age disparity between the deposition rule age and 804A. Nobody could make that disparity make sense. So the purpose of this conversation initially was, how does that make sense in terms of how we're treating young people who are alleged to have caused harm? I did forward to Nate a Supreme Court case that is squarely on point if the concern is about 804A, not 807. That's a different rule altogether that we're not here to talk about. 804A and whether it violates the Confrontation Clause. State v. Gallagher Supreme Court decision that you all have now, if you haven't opened up your emails, squarely says it does not. So we're not here to debate 807. We're here to look at what 804A currently allows. And you've heard from many witnesses who work with adolescents, 13 to 15, who are saying this will make a difference. And when we talk about, putting a brick on the scale in favor of children, because they are children, it really ignores the incredible power imbalance that currently exists when a young person, again, as you had heard, is saying, I have this job. I don't want this job. I just don't want to be hurt. I just don't want anybody else to be hurt. And in this day and age where social media is so pervasive, it's so toxic, it's a lot to ask. And, again, there are so many hoops to jump through in these cases, so many hoops that still exist. 804A has those pieces, which also require that a court, the judge, find that indicia of reliability. So it's a separate inquiry over and above what the people who are trying to introduce their statement. It's a whole other threshold. So I really want people to think about the context of the law that exists, the rule that exists in 40 other states, that we have case law that supports that it is in fact not a Confrontation Clause issue. Again, talking about 804A. And I really hope that this committee will, again, get back to the reason we're here, which was 2 years ago, we wondered why are our deposition protections different for young people in Rule 15 than they are in 804A. We're talking about 13 to 15-year-olds, and I really hope that we can ground ourselves back in why we started this conversation to begin with. But I don't have anything else to offer, and I appreciate the opportunity to weigh in. Thank you.
Thank you. Yeah, Tom.
Yeah, I have a question for Kate and then a question for Samantha.
Bring Kate back.
So you had said something about, and I heard it earlier, the first day we took some testimony on this as far as making it easier for the state to prosecute, I think is what you said. And in your experience with these types of cases, have people been getting off because it's not easy to prosecute? I think that's the question I want to ask.
I'm sure sometimes, I guess. The cases are just outright dismissed potentially if a child witness doesn't want to go forward. But I think more frequently it's a bargaining chip between the sides to either plead the case down a little bit and agree to something else. It's usually used more as a bargaining chip. I rarely have prosecutors come to me and say, my witness can't do this. But they might come to me and say, I'm willing to offer your guy X instead of Y. Does that make sense?
A little bit for a non-lawyer. Yes, it does. Thank you. And Samantha, in your testimony, you mentioned the science as far as, and the way I understood it was that it's going to be beneficial, I guess you could say, emotionally for the kids to be able to do this. And I can totally appreciate that. As far as the age of 16 goes, why 16? Is there science behind it, or we've also heard in some testimony it's just an arbitrary number? Why not just to 13 or 14 or 15 or 17, I guess?
Yeah, I would say, so there is definitely science to support that testifying as a victim of sexual crimes or allegations, I should say, is really, really traumatizing. It in fact is often referred to as a second rape among victims because it is so challenging and so painful to have to endure scrutiny about their experience and to hash out every single detail and to be criticized for how they can remember and how they can speak about it. And I mean, just imagine you're sitting in an open courtroom with whomever there is there to witness this, and you're having to hash out these things about your genitalia, your private body parts, things that have happened to you that you feel are so heinous and so awful that it was hard for you to talk about in the first place. And now you're having to hash it out in front of all these other people, complete strangers to you, asking you the most intimate, awful questions. It is absolutely re-traumatizing. If it was up to me, no victim would have to do this in open court and have to be subjected to the kind of treatment that they are because it is so awful to experience. And I, in fact, at my own child advocacy center where I work, had a teen come here and say to me, tell me what this would be like if I decided to go forward with this. And so we walked them through what the projection could look like up to and including court. And they said that the overall process didn't feel like it was going to be worth it to them, and they would rather just go to therapy. And the ramifications for that, how detrimental kids are worried that court is going to be, and how detrimental it is in fact, which again, research and science supports, is absolutely, I know you didn't ask me this question, you asked it of Kate, but is absolutely a reason why a lot of offenders are going without charges and without any punishment. And people are just either not coming forward or saying they don't want to engage in the process.
Right. So why 16? I can appreciate the expansion of the age, and the reasons for it, but why 16 and not 15 or 17? Where's the number? And I know other states have 16. I mean, why did they pick it? Choose 16. Why are we? I'm not agreeing, disagreeing. I'm just curious.
Yeah, I don't know, to be honest. I didn't pick 16. Like I said, if it was up to me, I would pick 25, 30, 45. I would pick no age, but I don't know. I don't know why
Okay.
16.
All right, thank you.
And I think it's actually 50, it's
Up to.
under 16. Yeah, it's all right. Yeah, so, yeah.
Missed it by a day.
Right. All right, great, thank you. So like I say, we'll have some further discussion. We can all think about this overnight and review any testimony. There's a lot of written testimony as well. And we'll, did you have a question?
Yeah, I don't have a, do you have a,
It's a process question. So
mine's not quite processed, not really for a witness though. So do we have somewhere, I was just looking on the website for this bill, like just to break down what hearsay exception age is for each state?
I think it should be posted under.
It should be, I was just trying to find it again. I couldn't. So I'll just, but we have it somewhere, and I just want to review it again.
Yes.
Okay.
I can certainly resubmit that to Nate, but I do.
Okay, all right, yeah.
It was already been submitted. I just was going, I just wanted to look at it. So we do have that material somewhere. Right.
So a process question is, so you said we'll have committee discussion tomorrow, maybe a vote.
Yeah.
Are we gonna have another version of this? Because I know we wanted to, at the very least, change the effective date. And there was discussion about potentially the title or the statement of purpose. Maybe that's in the discussion,
Well,
but I
you can
just,
change it to July 1st, 2026.
yeah.
Right.
So, and I didn't know, because you said possibly a vote. I don't know what other factors are being considered if we're gonna vote. Is it,
Yeah, I mean, yes, that's a good question.
is it
I mean,
more
we'll see if we're
testimony?
all-
or-
If everybody looks at this and feels they need more or more time, then at this stage in the session, that's fine. I mean, I'm expecting we will be able to vote tomorrow.
So if I have concerns, I should let you know before then.
Right.
But I just knew about the version. I want to make sure we have an accurate
If
version.
we find out that tomorrow during our discussion that there are concerns that need some further, that's the only thing. I mean, I think we've gotten all the testimony that we probably need, I would imagine, but anything else for that? All right, so thank you very much, witnesses. Really appreciate that. I just have one other thing, and then we're going to take a short break. So there's still one issue that I think that we haven't fully understood, or at least I don't think I fully understood. This is a different bill, you guys. So it's on H 545, which we are just doing a drive-by on. And that's the gross negligence standard, and whether that was raised by Adam McCrassen as far as whether that should be negligence. And I would like to understand of why it's gross negligence. So I'm asking Lauren to return at 2:30 so we can get that additional testimony and have her explain that. So perhaps she can also explain this issue of whether the informed consent and how that may or may not play into what we're trying to figure out here. So we'll be back at 2:30.